Um, can you hear me now?
Yes. Okay. Uh, I think everybody had some trouble. Would you mind with your announcements again so we could all hear you?
Ah, okay. So once again, welcome everybody to our WAD webinar. We have a very special speaker and guest today, Dean Beers. And before we start, a small announcement. If you have any questions, please use chat or raise your hand, and at the end of the presentation, we'll have a discussion on the questions, or if you'd like to share the information on the current situation with the virus in your country, please also join us for discussion. Uh, Now I pass the word to Dean. Thank you, and sorry for the inconvenience with the sound.
That's great. Thank you, everybody. Thanks, Alexi, and thanks for really putting all this on. I've enjoyed all the others. Glad everybody's here from around the world. Hopefully, everybody's doing well under the challenges that we've all faced, and learned something from each of these. So I hope to share things with you. Alexi's going to be watching the questions and answers because I won't see him, but we'll get things rolling here for you. So today we're going to talk about the best business practices and how they also intermingle with PI ethics. Generally speaking, for us, these are the same around the world, but a lot of this, of course, is based on some of our US stuff, but I think we all use it interchangeably. And it also works really well with what Juan shared last week. So, but we'll talk about some of the ethics that fit into our business practices and best practices. I'm not going to belabor a lot about me. I'm a member of WAD, the Governor of Americas, member of several associations, including our state association, Professional Private Investigators Association of Colorado, and I think I'm on auto move. Great. I hope not. So anyhow, that's my wife, Karen. She's your administrative manager, and we're on auto go. So we'll just move along as fast as this is going. So WAD ethics are pretty simple. They're found on the website. Each country has certain standards of practice and ethics, and WAD focuses on some of the specific ones for us internationally, and they're also some of the same for each of the associations around the world in each of the countries and each of the states in the US. For WAD, we hold the highest ethical practices that we expect from each other, and we treat each other well for that. We also strictly observe the truth and accuracy of what we're doing for our clients and with each other. And we also expect good cooperation among our members. And we also have trust and goodwill. And of course, with WAD, we have friendship worldwide. And I think that's very important for all of us and something we can all associate to. So about privacy and ethics, for all of us, it's pretty much the same. An invasion of privacy occurs when we encroach or infringe upon somebody's seclusion or solitude, their space, not the 6-foot social distancing space, I guess, but could include that. And something that a reasonable person, a person in our field or our clients would consider such an encroachment being offensive. The big thing that we have is using any deceit or trickery in invading a person's privacy. And that especially is when we're doing the work of our clients. We need to be very careful of that. That comes with financial matters such as bank account locates. It also comes with assets and investigations. It comes with counterfeit investigations. It also comes with locating individuals, whether it be for litigation or adoption. So we need to be real careful of those and how we protect ourselves, our agency, as well as our clients and even our subjects. So even in workplace investigations or counterfeit investigations where you're using undercover operatives and agents, that's not considered deceitful as long as you're not causing something to happen or participating in something that would be illegal or another person to do it. So we have to be real careful of that. This may be more than just physical, especially when it comes to trespassing. It may be virtual, like fax, phone, emails, any form of communication. Now we have Zoom and stuff like that. So if you're using some sort of pretext is to illicitly or illegally obtain information using Zoom even, or something else where you're trying to trick somebody into giving something that they should not be giving you and that you're not legally entitled to have. Those are things that are considered an invasion of privacy. So our ethics and our standards of practice come together when we talk about certain things, and in each country, we all pretty much have these same things, and Juan talked about some of these last week, and I'll expand a little bit more and a little bit differently on some of these. We have contracts, reports, conflicts of interest, confidentiality, record keeping, and advertising. And we have to be truthful and honest in all of those, working with our clients as well as the general public on these. So specifically to contracts, as Juan mentioned last week, contracts are recommended, but they may not be required. For example, in Colorado, we're not required to have a contract with attorneys that regularly use us. We can have a once-a-year contract. We can have a memorandum of understanding or letter of engagement or some type of agreement. Between private investigators, it's the same thing. However, between all other clients, such as you might have a family case with domestic surveillance for child custody and things like that, you do have to have a contract, and we highly recommend it. Contracts internationally can be difficult to enforce and expensive. Between WAD members, the contract itself is not a necessity. However, like Juan mentioned, it's important to have a non-disclosure agreement if you're going to be involved in that type of work, such as counterfeit operations, undercover work, workplace environment, or at least a memorandum of understanding or a letter of engagement that details what services are going to be done, what those are going to cost, the time frame that they're expected to be done by, and as well as any reports or other things that you're going to be providing to your client and by what time. As I mentioned, the fee schedule is recommended either within the letter of engagement specific to that, or have one available that you can share with other WAD members so they know what your fee will be. And you can have those discussions to make those arrangements. As I mentioned, for continuing clients, agreements may be standing, for the year or a certain period of time with an expiration, or they may be on a case-by-case basis. Also in the contracts, we need to make sure that, or letters of engagements or your memorandum of understandings, make sure you include certain things even between WAD members. The date of the contract is important, who's involved is important, and as I mentioned, the description of fees. If the contract will terminate, and this is especially important with undercover work and surveillances. You don't want somebody to continue an investigation or expect an investigation to be continued by your client longer than it was intended to be or should be. For other investigations, like we do death investigations, things like that, assets, locates, probate cases, those things don't tend to have a termination date. They just have a termination when the assignment's completed or the budget is run its course. What's not on here, but also important, is any details about the retainer. I forgot to include that, but you want to have that information as well. There are some cases between association members, including WAD. Retainers may not be collected up front and right away. It just depends. There may be billing when the assignment's done or through the course of the assignment, but you need to have that clearly in your contract or your memorandum or your letter of engagement. And then one of the other thing is you need to include anything about the manner of the report you will have. Some state licensing in the US and other countries require that a report be provided, whether it be oral or written, and some of those circumstances may differ. And I don't know that we can talk about all those, but in the US, there's a difference between criminal cases and civil cases, and when we may or may not be providing a report with attorneys. But that's something that's taken care of through the contract. But you do want to make sure you have a distinction of whether it be written, oral, or both, and as well as when that report should be provided. So on the reports, and they differ with what's going to be in the report depending on the type of assignment, but it's important to be as clear in your report as you can be. The formats might vary a little bit depending on what you're doing. Our death investigation reports are completely different than our asset locate reports for the US, but they all have some of the same basic information, and the same thing that we find in our contracts, the dates, the parties, things like that. You want to include in your reports the activities that were completed and any findings that were done and any supporting documents. So for example, in our death investigation cases, our initial activities usually include reviewing all the official records, reports, photographs. So we would include that, and we would include our analysis, and then we would include our findings. And if there's any specific supporting documents, we would provide those, especially when it comes to the attorney cases and the insurance cases we do. However, in our asset locate reports, the activities really aren't there. It's a matter of collecting the records and researching the records and verifying the records. So those would be our activities, what we researched, and then our findings with that. And of course, anything that we collect from a provider such as a courthouse or title company or something like that would be in our supporting documents. If there are any other details specific to the assignment, that's also helpful. So in our reports, we might have a section that's the summary, the executive summary, which provides just an overall of it. A lot of people like to place those at the beginning to give the reader a quick synopsis, and that way they can come back to the details later. But we also provide a summary at the end of little things such as what's within certain documents that they might copy and paste and send to their client, such as the attorney send to their client without the whole report. So it's a quick synopsis. We also have a place where we recommend recommendations that we're going to carry through with, or that they should carry through with for us. So we might find things in the investigation, whether it's surveillance or a death investigation or counterfeit investigation, and you might have those recommendations put in there. Your reports, for the U.S., our witnesses and our reports are basically fact finders, which the investigators are. And there's also experts and expert consultants, which we also do. And those are persons that can form opinions. But your reports as investigators should only state facts that you have. You should be very careful to avoid putting in opinions. There's several reasons for that. For example, if you were doing a homicide investigation or a wrongful death or a suspected homicide investigation, and throughout your report, you consistently put, this is clearly a homicide, this is clearly a homicide, which I've seen too many times, and then the family and the attorney or the insurance company gets that, there's no way, no matter what the evidence comes to be later, that they're going to ever change their mind. And if you do go to trial with that or go to any hearings with that, you're going to have to supporting why that is clearly a homicide versus something else. And if your report doesn't support that, you're going to have a lot of difficulty. And I've seen reports that have said that, and they clearly have not supported homicide. They've just put in a lot of opinion of why they felt it was homicide. It becomes very difficult. The other reason you don't want to put opinions in your report is your opinions might have to be disclosed to the other party, and you may not want your opinions disclosed to the other party. You may want your opinions, which could be very valid, only disclosed to your client, which is very important with attorneys. So you might have a separate memorandum that would cover that confidential work product memorandum, which I'll talk about, that would cover what your opinions are, which is okay. It's okay to have opinions. It's just not okay to put those within a report as if it were a fact. So we need to be very careful of that. As I just mentioned, the work product memorandum. So these are things which your clients will see and may or may not be disclosed to the opposing party, but your reports always will be. So your memorandums are for you and your client only, but the reports are for you and anybody else involved in the case, including judges, adjusters, juries, things like that. And they can be used in your depositions and any other hearings that are involved in. So your memorandums are important communication between you and your client. Your report should also be prepared to answer any questions for you, so that when somebody's reading it and you're testifying, you're consistent with your report and your fact finding, especially under cross-examination. So in reading your report, and have somebody else read your report, for example, Karen always reads my reports, I always read her reports, and that way we can make sure that what we're trying to convey is very clear to somebody that's not familiar with the case at all. So that could be a judge, a jury, an adjuster, things like that. We also want to make sure that our report is very clear for our clients who does understand the case and needs to have that understand the perspective that we're giving them. And of course, our reports need to make sure we don't have any errors and that they're consistent and without any inconsistencies, especially if we use templates. You want to make sure that you delete anything that's in a template that doesn't need to be there. And we do use a lot of templates. It's just much easier and much faster. And then we can just put in our specific case information for that. And basically a template, you know, what I mean is just a form and stuff like that. I know we're going a little bit, so if anybody has any questions, feel free to let Alex know and he'll get that question to us and he can chime in whenever if there's a good question as we go through with this.
And we have actually one question. Can you hear me now? Okay?
Yes, Alexi, thank you.
Looks like some most technical issues. So we have a question that from Israel. So professional ethics without a regulated code of ethics, our professional activity of private detective may be reduced. Don't you think so?
If the ethics reduce the level of activities we can conduct, am I understanding that correctly?
I think so.
Okay. So in the US side, I've had this question as it relates to investigators going to Mexico, and our ethics with what we do professionally differ from country to country, and I understand that. So particularly with Mexico, it came up, if you need to bribe somebody to get some information, can you do that? And it's not ethical. I can't debate whether a person should or shouldn't do that, especially in certain circumstances where in order to complete a counterfeit operation, you might have to arrange something with somebody that expects a bribe, because otherwise they're going to start believing that you're not who you're portraying yourself to be. So ethics are meant to confine us to making sure that we only do things that are legal and acceptable, particularly with attorneys. And in the US, when we work with attorneys, we're actually their agent and responsible to their ethics as well, or they could get in trouble for our actions. So ethics tend to be that type of thing that we think of it as a solid line, but ethics can be bent a little bit as long as we're not endangering our clients, literally in their harm or their case, and also the case itself. So we don't want to endanger any of the evidence that we're collecting. It'd be bad to collect all that evidence and then have something not used because you collected it unethically and were caught, or whatever the case may be. Does that help our member, Alexi?
Yeah, thank you. Thank you, Dean.
Sure, thank you. So let's, and I appreciate the questions and clarify anything that we talk about. Let's talk about conflicts of interest, which are very important to both ethics and our integrity as investigators. We have to make sure that we don't have any conflicts in the work we do, not just with our clients and our subjects, but also within the realm of, is there conflicts with potential litigation of other parties that we're not, that we become aware of, that, and we don't want to be working for two parties at once on the same case. We don't want to collect money from two parties in the same case. We certainly don't want to have contracts with two different parties in the same case. So we have to be careful of that. And that's basically to make sure that we have a very, so to speak, clear mind of what we're doing and without any influences on what our findings are and what we report. So we always have one party who's the client. I mean, that could be a person, that could be a group, that could be a company, but we have one party who's the client. Now, if multiple parties agree to have you as your investigator, your agency, your security agency as their client, such as in a class action civil lawsuit or multiple criminal defendants, as long as that's agreed on and everybody's disclosed as to what's going on, that's okay. We just can't have multiple parties as clients, especially when they're not disclosed. So we need to have that agreement. The compensation should only be under the party that's contracted with, unless there's a specific agreement as to multiple parties paying. And the reason that's become an issue with a lot of associations in our profession is not necessarily because of nefarious billing by PIs collecting money from multiple clients when they shouldn't be, but it's also a matter of record keeping, so that there's no confusion as to who is paying what. When we take on multiple clients, we always require that the lead client, the lead attorney, or the lead firm be the one to pay the bill and then collect from their others, just like they do everything else when they share their expenses and stuff. So the overall thing is to make sure that we avoid any clients, avoid any conflicts of interest, especially anything that might look like we're leaning in favor of loyalty or something like that versus what the outcome of the investigation is we should have it. And for those that do domestic surveillances, security surveillances, security workplace incidents, and counterfeit investigations, this loyalty becomes very important. It helps with your integrity and helps that you're keeping a standard of practice and your ethics in line on that without any conflicts. If somebody questions your loyalty to the case, they'll question everything else, including your final work product. Confidentiality is important. I know internationally countries differ quite a bit. However, I think the common ground for all of us is that our work product, what we do for our client, is only between us and our client. It's not something that we can share with other clients or other colleagues in any kind of detail. We all like to tell war stories that are very interesting. And as long as we're not disclosing anything that might violate that confidentiality, we're okay. When Karen and I do our death investigations, we have to be very careful that we don't disclose anything about the families or the insurance companies or the case that we're working about. We can talk about the general things, as in what happened, how it happened, and what the outcome was, but we can't be specific as to where it took place or names and things like that. We might mention a state, but we can't mention certain things because we never know if that conflict might come up or if we might be talking to somebody that knows more about it than we intended. And we need to protect the integrity of that case, especially if anything goes to trial or goes to appeal. So always be very careful about war stories, even with active cases. Probably kind of best to avoid some of those if we can. The one thing is that for confidentiality, as the investigator, we don't get to waive that confidentiality. Only the client that signed the contract can waive that confidentiality. And if there's multiple clients or multiple firms on that contract, they all have to agree to that. And we always recommend in writing that there be any confidentiality waiver on that. It's not required in most places, but we highly recommend that any waiver of confidentiality be in writing. The couple exceptions to this is when there's a subpoena to produce certain documents or produce the information of the case, or if you're subpoenaed to testify or summoned in any kind of civil or criminal litigation, you may be asked to waive confidentiality. Generally speaking, if it's something new to you, definitely seek legal advice. If it's not, such as you're subpoenaed to testify at a trial or a hearing, then of course, you can deal with that as you normally may. That's pretty routine. You know what your limitations are, and your client, if your client's an attorney or their attorney, if not, should definitely be able to help you in advance of what your limitations may be. So just be sure and understand that if you're asked to produce any documents to somebody under a subpoena, I would definitely check with an attorney, and I definitely would not provide those without consulting the client on that first and make sure that you're in compliance with everything. We don't often get asked to produce our anything from our case files, but at those times we do, we always make sure we let the client know, we get the client's written opinion on that. And so there's been a couple times there's been some disagreement, but we've worked that out. But generally, once they approve that we send the information, we also send the same thing to our clients so that they know exactly what we've given. So you want to also have that communication as well. Record keeping is something that's important, and I don't remember that Juan really talked about this too much last week. He covered a lot of really good things, but record keeping is important. It's a requirement under many licensing programs in the United States and a couple other countries that I'm aware of. Canada, several in Europe and the European Union have record keeping requirements. I'm not sure the specifics of all of them, and these may differ but these are common here in the US. You have to keep separate files for each client. And now that everything's digital, it's a matter of keeping things in their own folders, just like in a physical filing cabinet. You don't get to shove everything in a box, and just mix things up. I don't know anybody that does that, but who knows? We also have to keep things for a minimum of 7 years. And the 7-year question comes up quite a bit for us. Is that 7 years from when the case is closed with us, or is that 7 years from when the case maybe finishes trial, or is it 7 years from an appeal or something like that? So you need to use your best judgment or recommendations, or if it's specified in your law or statute or regulation, definitely go with that. So as a rule of thumb for us, we keep any records for a minimum of 7 years from the date of a final adjudication. And if we're notified that there's going to be appeal, then we simply keep that, which we'll be notified well within 7 years. We just keep that, and then we'll tack on until that continues. Right now, we have 2 cases that have gone on for greater than 10 years. They're both in appeal. So of course, we're keeping those records for longer. There's generally speaking, nothing says you can't keep them longer, just if you want to, and it may be a good idea for you to, but you need to be careful of what you keep. You also need to be careful or of how long you keep. You also need to be careful of what you keep. Some requirements are that you keep all your written notes, and there are some that don't. There are some that allow you to destroy certain things, such as your notes or payment records or things that aren't applicable specifically to the case. But generally speaking, you should have a policy that just delineates exactly what you're going to do and follow that. We just keep everything. We keep our work product separate from our work product within the file, so that we don't have to turn over anything that's considered work product to somebody. For our expert cases, we actually have to keep them a little longer. We have to keep everything. We can't destroy anything. And that includes any notes that we have, handwritten or otherwise. So we have to keep those and separately from our reports in case we're ever asked to disclose them. But for our standard PI cases, we don't have to do that. But your policy also needs to be the same one for all. So in other words, if you're going to permit yourself to destroy records, certain types of records at a certain time, you need to be consistent with that. Or if your policy is going to say you're going to keep everything, you need to be consistent with that. So the important thing is to be consistent. Record keeping also requires prevention of unauthorized access or loss or destruction. And this has really expanded a lot in the digital age. So we scan our documents and digitize them. We keep them on our hard server here at the office. And we also keep them on a cloud server, our working server. And then we also use Carbonite backup to back up everything that we have. So the Carbonite backup is only for our purposes. It's not for record keeping specifically. The cloud service is also for record keeping. And then our hard copy is what we have. It's more of a redundant habit now because that's how we started before we had the cloud service. We've always had Carbonite, we've always had the hard drive, and we've added the cloud service earlier this year, late last year, and it's worked out real well. So you want to make sure there's no unauthorized access. That includes usernames, passwords, things like that. Prevention of destruction, which is another reason for redundant storage. When we traveled, actually it was to WAD in Miami. I came back from a conference in Florida and carried up, and the next morning we flew back to Miami for the WAD conference. Well, overnight, somehow I had lost 30,000 work product files for our investigative cases on my hard drive. That was not a fun thing. So during all that time while we were at the WAD conference, Carbonite was backing up our system with all the files. We didn't lose any, thankfully, but that's one of those things we have to be very careful of in our standard of practice. So if you don't have that set up, I highly recommend setting that up. And if Thomas Mathiasen is listening, he's really good for helping you guys get us set up with cloud services. What you should have in your record keeping are all your contracts and agreements and exhibits or attachments or inclusions that you have with them, like your fee schedules and things. You need to know when you started your file so that you know how long your time will be, 7 years. And then you need to have for sure your final written reports or any memorandums and any notes that you might have of verbal communication that would be important to have for that. And then if you have timesheets or activity sheets and expenses, those are important. And those are the minimum that you should have in your record keeping. As I mentioned earlier, if it's expert work, you have to keep everything. If it's just straight PI or security work, you may not need to keep your draft notes and things like that, but you should check with your licensing and your laws to make sure that you're compliant with that. And then our contracts require us to have our information readily accessible to the client. That does not mean that they have access to our records in any way, including online. That just means we have to have them so that we can give them to them, our clients, in a reasonable amount of time of their request. And reasonable is not stipulated for us in our state licensing, but we try to do it within a business day to have that to them. But I think if you can have a policy that says, 2 to 3 business days, you should be okay, unless you have a law or something that says different. And I'll go do this advertising real quick, and then we'll see if we have any other questions from Alexi. One of the last things, particular to these standards of practice, is advertising. And advertising is important to all of us, especially for networking and things like that. So this is pretty much the same across the board from what I've been researching. We need to, and there's more specifics to this, but we advertise with our logos, our licensing, what we do and things like that. I mean, that's all pretty normal. But we have to avoid in licensing is anything that associates us with government, law enforcement, or anything that we're not. That goes back to privacy invasion, pretexting and things like that. For surveillance and stuff, in security, if you use vehicles, you don't want them to suggest or somebody to look at that and go, oh, that's a police officer, when you're not. Same thing with any uniforms or badging that might somebody look at you and say, you must be a police officer. So on those 3, that's not to say that you can't have any security vehicle, or security uniform, and a badge that says security officer. I'm not saying that. And those are very clear and very distinct, but we just want to make sure that when we're knocking on somebody's door or interviewing somebody, that we're not giving them the impression that we're somebody we're not, a government official or law enforcement official. And that goes with the next one, presenting any false qualifications. That includes identification, any responsibilities or subjects or assignments. You don't want to present anything false about you or what you're doing. I'm not talking about undercover work or workplace environment work where you're having an undercover agent doing that. You're of course going to be representing some false information, but that's acceptable. I'm talking about when you're trying to obtain information that you would not otherwise be able to, interviewing people, doing surveillance, stuff like that, where you're might influence the investigation or might influence what the person responds to you, to your questions and things. And then the last thing in advertising is don't use any false or deceptive advertising. The big one that we always hear about, at least in the States, is somebody advertising that they provide certain types of services when they don't. They're not capable of it. They don't have that experience, but it's something they put out there just to draw attention to their agency and hope to get the phone calls. So we're all pretty good on that with WAD and the other associations I'm a member of. It's, we all do our advertising. We just have to be careful with what we do and make sure we're honest with each other. Alexia, I'd like to see if anybody has any questions for us, or if they do.
Let me see. Yeah, I think we have a message from Deborah Allen. She says that she has a comment and suggestion.
Sure, Deborah.
I always require a consent for contract agreement that is to be notarized before I will reunite a family separated by adoption and missing persons. I do not disclose any names and contact information without a signed notarized consent from both parties. This may help others if they are concerned with confidentiality is comprised. The client knows this up front, and if they have issue, I will or take their case. I will not take their case, I guess. And Deborah also offered to share a sample of this consent for those who need this. I can put her email in the chat, so you can contact her in case you're interested.
Yeah, Deborah, thanks for that. And Deborah's in Arizona, and she does genealogy and adoptive research. I know Jim Zimmer is on here from NCISS, and I believe he was involved at the board when NCISS passed a resolution stating that we, as members, we could not disclose information about the subject without their permission when it came to these types of things. So to touch on that, and they're very good points, and I appreciate them. Thanks, Deborah. And she does have a good disclosure form. I've seen that, and we use something very similar. So when you're doing an individual locate, if you find somebody and it's not for litigation, so you're not finding them as a witness or as a party to the case or something like that, but you're finding them for adoption, genealogy, or some other reason, a welfare check, you should have an agreement. We have to have an agreement that says if you're looking for, say, the adoptive daughter of your client, and you contact that daughter, your agreement with your client, the mother will say, I will contact them, I'll disclose who I am and what we're doing, and I'll get their permission to disclose their information back to you. If there's no agreement from the mother to do that, then no, you should not take the case. They need to have a clear understanding that the subject that you're investigating and trying to find has the same rights to privacy. And there may be a lot of different reasons for that, personal reasons for them. So take notice of that and follow that. And that is good advice. And if anybody wants to talk about that a little more, feel free to email me or give me a call or something, and we can talk about that a little more. Or if we have time at the end, we can come back to it. It's not a very long subject matter, but it's something that's pretty important, and maybe we can spend a little time on that. But I appreciate that that was brought up. Thanks, Alexi.
Thank you, Dean. We have another question from Bernard Meyer, and if you're not against this, I will just unmute him and he can turn on his video as well. And he has a very good question. Let me see if he, yes, Bernard, you can now use your video or audio.
Can you hear me?
Yes, yes.
Great. Thank you for the presentation so far. Whenever we were speaking about ethics and standard of practices, there's one question which comes to my mind, which is pretexting. Do you, generally speaking, consider pretexting as unethical?
Thanks, Bernard, and thanks for being on. So the question of pretexting being unethical depends on the purpose of it. Specifically for the United States, we have some very specific guidelines. So if you're using pretext to obtain information that you would not otherwise be able to obtain, that is invading a person's privacy, such as financial matters, things that would be illegal, then the pretexting, of course, would be. If you're using pretexting, and a common one is workplace, where you send, or a secret shopper, where you send in somebody to work for the workplace to kind of observe if there's any theft is common going on, or you might have the secret shopper for the same reason. Counterfeit operations have that. So pretexting might also be considered an undercover operation. The other pretexting is maybe that we commonly hear about is a conversation using a telephone, and also with modern technology using video services or email, where you convey information about who you are that's false, and hoping to obtain information from that person that you shouldn't otherwise have. And again, that's privacy related information. So years and years ago, it's illegal here in the US. I'm not sure, I know other countries still do it. They do it in the US, but not legally. You might call up a person and say, you're John Doe from a bank credit card company, and you're just verifying their account information, and you give them some information about themselves so that they are confident in you. You might give them their date of birth or their social security number, and then they in turn give you their account number, their account balances and stuff like that. That used to be a very common way to get banking information in the United States. It was never legal, actually, explicitly, but now it's explicitly illegal, and it has been for several years. So that's a pretext that's illegal. using using a pretext or false identity to get access to information, such as pretending you're the customer, calling a cell phone company so you can get their billing information, is an illegal pretext. But again, using a pretext as in maybe a counterfeit operation, workplace environments, stuff like that, and there are other legal pretexts, those are okay. Did that help you, Bernard, and our other listeners?
Yeah, thank you. Thanks a lot.
Sure, thank you very much. Anything else, Alexei?
No, at the moment, no other questions.
Okay. So and I appreciate the questions and clearing anything up, and I appreciate everybody being involved as best they can. Other standards and compliance that we have, some of these are pretty obvious, but I always clarify them with people, make sure we're all on the same page. You need to have all your permits and business licenses that you need to have. To join WAD, you have to have all that in order anyhow. Rock's going to check that out for new members before they're even submitted for approval. But things that come up are also any special permits and licensing you need, such as for security or a PI. If you're carrying a firearm, do you need a permit? Do you have the appropriate permit? So in Colorado, we just have to have one permit, not specifically for PIs, but in general to carry a firearm. However, in California, you have to have very specific permits, very specific firearms, and very specific training for very specific reasons. So you need to make sure all your ducks in a row are in a row for that. We cannot give any legal advice in Colorado. In the United States, we can't. That's a violation of both ethics and law. So we can't give any of the legal advice. We also can't act or conduct any illegal activities, which I think we've been covering. And you must do everything that's within the realm of your local and state or province laws, as well as your country laws and regulations. And you need to be well aware of what those are. So in the United States, not only do we have a lot of laws and a lot of regulations, but we also have agencies with their own regulations. So we have a Public Utilities Commission that, although it's not a law within a federal law or a state law, the Public Utilities Commission says that we cannot divulge any, or the companies can't divulge any customer information. And that's any customer information. They can't divulge addresses, phone numbers, billing history, anything like that. So going back to the pretexting question Bernard had, if somebody were to pretend to be a customer in order to get that information, that's the pretexting that's illegal. And even though the company didn't know that's what they did, they have to have safeguards in place to try to prevent that, which is why there's authentication things going on. We also can't discriminate against any person for any reason, whether it's a subject or a client. You can't decline a case. And of course, WAD is very good about this, and we're all very good about this. We can't decline a case because of a person's background, who they are, ethnicity, culturally, nation of origin, religion, anything, race, sex, gender, anything like that. So if you have any personal thoughts on something, when you take a case, you don't have any more personal thoughts. You just have a professional. So we all have to be honest that there are still biases in humanity and prejudices. I haven't seen it in WAD members and the colleagues that we work with, but we all have personal feelings and thoughts on things, maybe political or not, but we can't allow any of those discriminations to come into play with the work we're doing. We have to be very clear and very open-minded, and in doing that, it's the only way we get honest investigating done and honest reporting done. And on that, also note, when you're doing your reporting, you can't have any discrimination in your reporting. And that's not personal discrimination, but also discrimination in what you're reporting and how you're reporting it. So don't put something in a report to try to make it sway one way with your wording, or leaving information out, or even adding information. You need to be very straightforward and very open with your reports on that. Be very truthful in your statements, and as I mentioned, your reporting, and also might lead to your testimony. Have everything that's relevant. If it's not in your report, the rule of thumb is if it's not in your report, then you won't be able to prove later that it should have been and that it happened. So have it in there, have all that pertinent information in your statements, reports, witness statements, and that way if there's testimony, you're prepared for it. And of course, my ultimate goal is there's enough information in my report that I won't have to testify. And thankfully, I rarely do, because we make sure our reports are consistent enough. However, from time to time, there's reasons to have testimony or depositions, and you want to be prepared for that. As before, kind of with discrimination, you don't want to be engaged or associated with any illicit practices. No offense to the Hells Angels, but for example, being a member of the Hells Angels Motorcycle Club in any country might not put you in a good light as an investigator. If you are, and I've just offended somebody, sorry about that, but we all have to be careful of how we associate and what we associate with, so nothing that we do is deemed to be illegal or wrong. We also definitely don't want to be violating any court orders or injunctions. In this time now of this worldwide virus pandemic going on, there's a lot of rules and regulations going on, a lot of discussion about them, a lot of personal opinions about them. But no matter what your personal opinion may or may not be, if there's a rule out there, a law out there, a regulation that says you have to do something or you can't do something, that's what you have to follow. So if there's a law that says you can't contact a witness that's represented by an attorney, well, you can't contact that witness if they're represented by an attorney. We have that here. And if we contact somebody and they tell us they're represented by, we don't know they're represented, we of course have to determine that right away, and we would ask. And if we find out they are, then we can stop, and that's acceptable. But if we know they're represented or advise they're represented, we still do it, that's not a good idea. And there may be indirect representation. So for example, we had a case a long time ago in which the person was a police officer working at a school. He was assigned to the school, and there was one interpretation that said he was an employee of the school and therefore was protected by the school's attorney, the attorney representing the school in this lawsuit. The contention of our client was that he was a police officer who was not a party to litigation, and therefore it was okay for us to contact him. Ultimately, that was the decision that won, and we were able to contact that police officer. However, we had to wait for that legal decision making to be completed in order to contact them, so we have to be careful of that. When we also contact these people, and this goes back to Deborah's point, we also need to possibly make sure that we don't disclose any information that may lead to a protected person, such as by a court order or something like that. So for example, in an adoption case, if the person says, no, don't give my information to anybody, I never want to hear from them again. When you make a report to your client on that, do not report anything that might insinuate who they are or where they are. So don't say, I tracked down your daughter who has since changed her name and married and lives in a Rocky Mountain state, which would, for us, would be Montana, Wyoming, Arizona, Utah. Well, that's too much information. You just need to provide the information that says, we contacted the person you identified as a daughter you gave up for adoption, and she declined providing any information about her. That's honestly all you can provide. Nothing else. And people will ask, we just got called yesterday to do a welfare check on somebody. It turned out not to be a welfare check. It was more of trying to find them and find out what they were doing. So you want to make sure that the case you're doing actually falls within that. So if somebody says, I want you to do a background investigation on somebody, and then they don't have enough information for you to do that, such as, well, I don't know what their address is, or I don't know what their date of birth is, or something important that you need, there's probably a reason why they don't have that information when they should. I mean, but so you need to dig a little deeper and make sure that you're not actually conducting a locate investigation, that they're calling a background, so that you get tricked into doing that. And I think all of us WAD members have years of experience in order just to be a member. And so that's information that, to most of us is obvious, but for some, it may not be, and I always share that. And the last thing is, don't engage in anything that's not acceptable or can be considered incompetent for our standards in the profession. And the incompetent part comes up particularly when I mentioned earlier in advertising. If I were to advertise surveillance, I would be considered incompetent to that. And it would not be right for me to either A, advertise, or B, offer it and do it, because I'm doing a disservice to my client, could jeopardize their case. So we don't want to do anything like that. We also don't recommend that people conduct death investigations unless they've actually done so because of the things involved in that. We have done a lot of probate cases. We've done adoption cases, but it's not something we would advertise because that's not an area that we would do, but we're competent in that. So you could also have that area where you could be competent in things, but you just choose not to advertise on that. So just keep those things in mind as well. So coming up to the tail end of this, these are the questions that I often hear about when I give presentations like this, particularly on ethics, is what laws can PIs break? And Bernard kind of led into that, and Deborah led into that. Everywhere in the world, we're just private citizens holding some kind of license that says we can be private investigators. There's no law, we don't hold any official status of anything, so there's no laws that we can break. We don't have the ability to claim an exemption to a certain law or regulation. We don't have the ability to say that, well, we didn't know about it, so, you know, therefore we didn't mean to. So some things that come up, for example, surveillance, running red lights and stop signs. I know it happens, but if you get a ticket, you get a ticket. You can't say I was conducting surveillance and the guy was getting away from me and use that as a legal defense, because at least here it's not going to work. Same thing with trespassing or breaking and entering. It's happened. It happens all the time. Sometimes it's inadvertent and sometimes it's not. So here in Colorado, you can go onto private property to serve a legal document, but you can't go onto private property to look in their trash can or trash can run. So, and I'm asked about this frequently. When somebody does a trash run, they dump the trash out, they keep it, they sort it, whatever it is they do. There's a difference between if that trash barrel is put out on the street off of private property or if that trash barrel is on private property. You can't go onto private property to get anything out of their trash for evidence and take it with you. You've committed a crime going onto the private property. Serving the legal document, because the only way you can serve that legal document is to do so, you have a legally permitted purpose to be on there. So those are two examples I give so that we're pretty clear on that. Same thing with stalking and harassment. That kind of comes with Deborah's comment and question. When we're conducting any investigations, background locates or whatever, make sure that you're not being used as an agent to actually conduct any third-party stalking or harassment. It's unfortunately too common to do that, not necessarily for PIs, but where people will ask friends and relatives to do that third-party stalking for them. And you may be even contacted by a friend or relative asking you to do something. We have taken calls, and all of us probably have. I'm calling for my cousin. They don't, you know, they don't know what to do, and I just told them I'd call and find out if you could, you know, follow my cousin's spouse and make sure he's not cheating. Well, your client's not going to be the one on the phone. Your client's going to be the cousin. So that's the person you need to talk to. If they're not willing to talk to you, you know, of course, decline the case without going much further. So just be careful of those. And same thing goes with invasion of privacy. This is all the same. It leads to the same. That includes checking phones, checking emails, bank account, computer accounts, things like that. Just because a person has access to it does not mean they have a right to it. So if somebody hands you a phone and says, this is my wife's phone, I pay the bill, I write the check, here's the passcode to her phone. In the United States, that's not legal. The first thing is the expectation of privacy when they have a passcode on the phone. That means they're not expecting somebody to have that phone unless they have express permission. I'm not going to get into a lot of details of the back and forth in that, but that's the short version of it. Hacking devices, same thing. And some people would consider GPS devices to be the same thing. Locally, right here where we're at, a boyfriend contacted our office and another local office to put a GPS device or sell them one on a car. We didn't, and neither did the other agency because of the conversations we had, but he did find a GPS device, purchased one somewhere, and he placed it on his ex-girlfriend's boyfriend's car and got arrested for that. He trespassed on the property. Putting it on the car was a trespass, and he had no, and then he was harassing and stalking as well. It wasn't the use of the GPS device, it was everything surrounding that that was illegal. That also goes with using those devices to violate statutes or regulations, restraining orders. That there was also a restraining order against the guy by his ex-girlfriend, which is why he thought it would be okay to put it on the new boyfriend's car, so that way he wouldn't be in trouble for putting it on her car. Either way, it was still illegal. The last thing is using resources we have available to us to violate any law, statute, regulation. This is very common when it comes to accessing what are our public records, considered public records in the United States, such as some driving records, property records, things like that. They're private in the sense that you have to have a certain reason to access them in some states, depending, but they're public in the sense that the government keeps those records. That makes them a public record, not necessarily open to the public, but retained by a public agency, a government agency. Driving records in the United States are protected by the Driver's Protection Privacy Act federally and also at the state level, and each state has their own specific DPPA. Colorado, we can access that record for certain reasons and get certain information from that record and use it for certain reasons. If I were to get a driving record of somebody without one of those permitted purposes, that would be illegal. Even though as a private investigator, licensed private investigator, I have access to it, the reason I accessed it has to also be legal. So you have to follow two reasons to get confidential records and use them. In our case, licensed private investigators, and then whatever the lawful purpose is. For litigation is our most common. Same thing with online database resources. When you go online to IRB, TLO, IDI, whatever the case may be, you usually have to get an opening screen with a checkbox that says, you know, are you one of these, which is a licensed PI, for example. And then you get the next screen that says, what is your reason? And you check that, and then you get access to your database and data. If you lie on any of those, then you've violated not only the terms of service with the provider, but also state, if not federal statutes, such as United States Fair Credit Reporting Act, Fair Debt Collection Practices Act. And one of my experiences a very long time ago, I started in 1987, and this happened to me in 1989, I think it was. I was asked to get a credit report for a collection by an attorney, which was a lawful purpose, and I did. However, when I obtained that credit report, what I did not pay attention to was that the company only provided pre-employment credit reports. They didn't provide credit reports for collection purposes. And under the Fair Debt Collection Practices Act and Fair Credit Reporting Act in the United States, that was a violation. And it's at the time, I don't know what it is now, but at the time it was a $10,000 fine for the violation. You know, I was able to explain to the attorney, the company I obtained it from was able to explain. And as a result of that, they had to change their prompt screen to say, we provide only pre-employment credit reports. So it was an honest mistake on everybody's part. The other side didn't raise a hassle with it, but they did alert that, hey, wait a minute, this is clearly not a collection report. You know, and we hashed out that way. So we all have our transgressions. We all have our problems in life that we learn from, and that was one of mine. Thankfully, it wasn't an expensive one, but it's one I won't forget, obviously. So make sure your reasons are legitimate as well. Alexi, this might be a quick time to just break in for any questions, if anybody has any on all that information we just shared.
Yeah, thank you, Dean. It was very interesting. Can you hear me yet?
Yep.
So we have a comment from Jim Zimmer. Even if trash can is in the street, if you find medicine to treat AIDS, for example, you may violate HIPAA law if you report that. Be careful.
Yeah, Jim, that's a very good point. Thanks for bringing those up. So let's go back to this screen real quick. It's not really an invasion of property. I mean, you're legally collecting the trash from the street because it's off private property. If you come across information that would otherwise be confidential, and what Jim's referring to is HIPAA, that's the law regarding medical records, medical treatment, health insurance, Portability and Privacy Act. There are certain exemptions to that. PIs have basically no exemptions to HIPAA. There are very few for very limited reasons. Even our death investigation cases, we have to have waivers from the next of kin to do that, and attorneys get the waivers from their clients for medical records and things like that. So yes, if you come across certain things, such as pill bottles, prescription information, medical records, anything that would be restricted that you would not legally be able to obtain, you should not be A, taking it, and B, reporting it. There are PIs that will say, well, if you just verbally report it, you haven't violated anything. And I need to go back and re-stress, you should not report it, because no matter how you report it, you're reporting it. So, and if your client references that, which an attorney would know not to, but references that you found a pill bottle, a prescription bottle in the trash for whatever kind of treatment, Jim mentioned AIDS, but whatever it may be, you're disclosing information and they're disclosing information which the attorney would know not to do, but let's just say they still did. You could be in some troubles with some issues. So definitely don't collect or report anything that would get you in deep trouble, as well as your client. And in the United States, if that attorney, if our client is an attorney, we also jeopardize their licensure as well as the entire case. So in law enforcement, not getting into the search warrant issues and stuff, but it works the same for us. If we collect evidence or report evidence and it's deemed not to be used in the proceeding, the trial, the hearing, whatever it is, you've jeopardized the case, and that may throw out anything related to it. So just be careful of that. Thanks for that comment, Jim. Alexi, was there anything else, or are we good to go?
Oh, looks like we're good to go.
Okay. Appreciate it. Thanks.
Dean, it was really great presentation.
Yeah, I think we just have, I think I have just 2 more quick slides. Can we cover those?
Sure.
Okay. And this is just wrapping up the defenses that a PI has. I covered the stalking, the trespassing, breaking, entering, things like that, using devices, resources. Oh, I went back a slide. Okay, I might only have this one slide. Sorry, Alexi. So everything boils down to most all our work product is within our ethics. WAD ethics is pretty clear, especially between members. Basically, we be nice to each other and pay each other and welcome the cases we give each other. We need to be aware that what may be legal may not be ethical, and also what may be ethical may not be legal. And I hope I've covered a lot of that in this. So we always want to make sure that our cases are both legal and ethical. No matter if we have a private client, an attorney, insurance company, business, whatever the case may be, we treat all of them the same. And we treat, of course, all of our colleagues the same, whether they're WAD or other association members or not. But, you know, it's all about respect for each of us. And I appreciate that with everybody, because I think we're all pretty respectful of each other. You and your evidence must be viewed as if it would be in a court of law, although it may never see a court of law. You treat it like it's going to go to court. You treat every case like you may testify. You treat every case like all of your evidence will be used, and all of your evidence will be scrutinized. So we just make sure, again, that our activity and our work is lawful and ethical. Wrapping up, make sure our clients, that we know all about our clients and our cases and what's involved in those legally and ethically, and how to do those competently. Be aware of WAD and any other association ethics and rules that you have and bylaws. Know the PI licensing of where you live, your state, your country, things like that. And know what the laws and regulations are about your case wherever you live and wherever you work. And if you're not sure, ask your client, ask an attorney, ask another PI. But just remember, you know, advice may differ, and for different reasons. Depending on where a person's at, they may not have the correct advice, or they may have better advice. Bottom line is, we're all professionals, and that's where we're at. I think we can end with any other questions or comments that anybody might have, Alexi?
No other questions. If somebody wants to ask anything. Oh, I see one. Mention Middle East. Great, thanks. Nice to know. Oh, people are writing thankful messages. So as I understand, nobody is willing to connect and ask something through the microphone. Thank you again, Dean. It was really interesting, and I can tell you that from all our webinars, it was one of the most prominent from the side that we didn't lose any single viewer. So all the people they stayed until the end of the presentation, which is a good sign and really a confirmation of how interesting it was.
I appreciate that, Lexi. I'm not seeing anybody's comments. I apologize. I don't have the comment screen, but I appreciate any of the comments people have. Our email address is down at the bottom of the slide here, associates@deathcasereview.com. If anybody has any questions, you're free to give us a call or email us anytime. Thanks again, everybody. Be safe, be healthy, be strong. We'll get through this. Thanks, Alexi.
Thank you, Dean. Thank you, everybody. Stay safe, and hopefully we'll see each other soon on our next webinar and then our annual meeting.
Yes, in Aruba.
Look forward to it.
Bye-bye.
Thank you. Bye-bye.